Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
That the original petitioners respondents herein entered into a collaboration agreement for development of a residential colony in Sector 62 Gurugram stop, that thereafter a further addendum agreement was executed between the parties stop. The dispute arose between the parties and it was the case on behalf of the original applicants respondents herein that the appellant herein did not comply with the obligations under the addendum agreement stop. The respondents original applicants petitioners issued a legal notice raising demand for physical possession stop and claiming a sum of rupees 10 crores for the losses damages suffered by them stop. As according to the original petitioners respondents herein the dispute between the parties were arbitrable, the original petitioners appointed a former judge of the High Court as their arbitrator stop. The appellant herein denied appointment of the arbitrator stop. Therefore, the respondents herein approached the High Court for appointment of the arbitrators in terms of Clause 37 of the addendum agreement by submitting an application under Section 11 of the Arbitration Act seeking appointment of arbitrators by the court stop. The said arbitration petition was opposed by the appellant herein by raising various grounds, including one of the grounds that the dispute falls under Clause 37 of the addendum agreement and not under Clause 37, which incorporates arbitration clause stop. Despite having noted that the Clause 36 of the addendum agreement stipulates that in the event of any dispute with regard to clauses 3, 6 and 9, other party shall have a right to get the agreement specifically enforced through appropriate court of law. The High Court has appointed the arbitrators in terms of Clause 37 of the addendum agreement by observing that conjoint reading of clauses 36 and 37 makes it clear that a party does have a right to seek enforcement of agreement before the court of law, but it does not bar settlement of disputes through Arbitration and Conciliation Act 1996 stop. By observing so, the High Court has allowed the application under Section 11 and has appointed the arbitrators who shall appoint the third arbitrator in terms of Clause 37, feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, allowing the application under Section 11 of the Arbitration Act and appointing the arbitrators with respect to the dispute between the parties. The original opponent respondent has preferred the present appeal stop. Shri Dhanesh, learned counsel appearing on behalf of the appellant, has vehemently submitted that while allowing the application and appointing the arbitrators, the High Court has not at all considered that, according to the appellant, the dispute falls within Clause 36 of the agreement and not under Clause 37. It is submitted that, as per Clause 36, in case of any conflict or difference arising between the parties, or in case the either party refuses or neglects to perform its part of the obligations under addendum collaboration agreement inter alia as mentioned in clause 6, then the other party shall have every right to get the agreement specifically enforced through the appropriate court of law.